They called 911 and told police officers their abusers punched them, put a gun to their head, even threatened to kill them. But a community watchdog investigation eventually revealed that police arrested those domestic violence victims and hauled them off to jail. Nate Morbido discovered the same justice system that victims look to for protection occasionally labels them as criminals.
Here are their mugshots. We've spent the last 2 months filing public records requests and reviewing criminal cases and jail logs, and discovered something advocates call horrifying. We found more than a dozen cases over the last year, the equivalent of at least one a month, where prosecutors put domestic violence victims behind bars. Jail, a place you'd expect to find hundreds of defendants.
Booking, camping.
But they're not the only ones locked away.
You planning on bonding?
On any given day, the Washington County Detention Center houses the last people you might expect, victims of domestic violence. People like Donna Oliver.
Thought they could help me.
She reported domestic abuse twice in a matter of 3 months last year.
He's thrown me down off the bed. I've gotten a Doc Martin to the face.
But after her second call to 911,
that was one of the worst experiences of my life.
She eventually found herself looking right into the lens of a jail camera as it snapped her mugshot. Her crime? Contempt of court.
I just thought, why? Why would you do that to somebody?
Prosecutors charged these other victims, all but one of them women, with the same crime. They all received one of these, a subpoena, in order to testify in court against their alleged abuser. All of them failed to show up, which is a jailable offense.
It's got to stop.
Bill McManus says just because the law allows for their arrest doesn't mean it's the right thing to do. He represents one of the victims.
She was arrested, had to post bond, and then come back to court, miss work, that kind of thing, and end up in the busted paper and everything else.
Court records show the more than dozen victims who faced the punishment of jail reported their abusers punched them in the face, headbutted them, choked them, spit on them. One said her boyfriend put a gun to her head. Another said her boyfriend threatened to kill her. Police took these pictures of one victim's injuries. The woman said her child's father dragged her down the stairs and threw her to the floor. She later posed for another picture, a mugshot.
We should expect more. We should expect those people to be protected rather than turned into defendants themselves.
Defense attorney Patrick Denton shared this voicemail with us.
This is 88 Marshall again.
Washington County's domestic violence prosecutor left the message with a victim earlier this year.
If you do not come in to the sheriff's office or to the Justice Center to be served with a subpoena, come 5 p.m. next week, I will issue a contempt warrant to have you arrested for contempt of court.
Denton considers it a clear threat.
I mean, it's kind of chilling. Here's a woman that called the police because she needed help, and now, a couple months later, she gets a voicemail that says, now you might be the one that's going to jail. I mean, think about that.
Consider this, too. In the heat of the moment, victims will call 911 for help. But in the months after, when they have time to think about the consequences of that call, some victims will reconsider whether they want to move forward with a criminal case.
I'm going to call our docket.
Afraid it could result in more harm than good. So they choose not to testify. In the past, prosecutors would dismiss many of those cases. Not anymore.
How paternalistic is it on the part of the government to think that they know what's best for these women?
It did catch me off guard.
Shocked by our discovery,
It re-traumatizes the victim.
Lynn Armstrong urged the system to allow victims to make decisions about what's best for them. She's supportive of prosecutors holding the abusers accountable, but says they're going about it the wrong way by holding victims accountable too.
What's the definition of abuse? It's power and control. So who's now taking that power and control over the decisions?
And argues forcing victims to testify will put them in danger.
It is deeply concerning.
She should know. Her sister is a domestic violence survivor.
I'll say this much. Had they forced my sister to testify against her husband, she and her children would be dead today. And this is not fair to victims.
I'm not going to go back and apologize for what I think that we done, because I think that we were doing the right thing.
Of the nearly 1,000 domestic violence cases in Washington County annually, District Attorney Tony Clark says the cases where victims are jailed are the equivalent of roughly 1%. A severe but rare punishment, he argues, is in the best interest of public safety.
If we don't, as prosecutors, do our job, then I think that the increase in the number of domestic violence cases and the severity of domestic violence cases is going to happen.
Clark says as much as he doesn't like putting victims in jail, prosecutors needed to send a message.
At some point in time, where do we draw the line in saying that we're just going to dismiss these cases if a victim does not appear?
He believes victims are essential to successfully prosecuting the most serious cases. Since his office started cracking down on victims about a year ago, he says more of them have started showing up to court. If they are punched in the face, if they are spit on, if they are choked, is there not a better solution than putting these women in jail?
And I'm glad you asked that, Nate.
Clark says prosecutors are in talks with the judges to see if there's a way to serve victims with a contempt of court summons instead of arrest. That would at least help them avoid jail, but they'd still have to appear before a judge in a courtroom. It's too late for Donna Oliver.
I've been a victim who's been re-victimized.
She says the damage is done. We were there last month as the state eventually dismissed her contempt case, but only after she spent several painful hours in jail, where she says she suffered worse injuries than she did at home.
My knees were badly bruised. You could see grab marks all over my legs.
Her attorney provided us with these pictures. Oliver says she suffers from anxiety and post-traumatic stress disorder, prompted by years of abuse. While in jail, she says in the midst of a panic attack, she begged detention officers to let her take off her own clothes and to not put their hands on her.
I was grabbed by both male and female guards, thrown down, maced.
Officers reported they used force and chemical spray, resulting in very minor injuries after Oliver made suicidal comments and made an aggressive motion toward a nurse.
Do I think we are re-victimizing victims? No, I don't.
Clark insists the cycle of abuse that Oliver suffered at home is the kind prosecutors desperately want to stop.
It could be to prevent harm to them later on or to another victim later on.
As for her injuries in jail,
That's no fault of the state, Your Honor.
both the state and judge said she is the one to blame.
You brought yourself to the jail for your lack of following the court's order.
One more thing to think about, a double standard. While some victims are sent to jail, the punishment isn't nearly as harsh for police officers who are no-shows in court. The DA says those officers are disciplined, sometimes ordered to pay court costs, other times punished by their departments. But he admits they're never sent to jail.
And the DA tells us before prosecutors started occasionally jailing those victims, they tried to bring them to court on what are called show cause hearings. But defense attorneys fought that too.
Well, Washington County isn't the only court system occasionally putting domestic violence victims in jail.
And community watchdog Nate Morabito continues to investigate and found out the severe but rare punishment is taking place in Sullivan and Greene counties too.
Remember, we found more than a dozen cases over the last year in Washington County where victims of domestic violence disobeyed a subpoena to appear in court and went to jail as a result. Advocates say the courts shouldn't force victims to testify, but prosecutors say they can't convict the abusers without victims' help. And police have a stake in this too. Domestic violence calls are among the most dangerous for officers to respond to. All of these women, along with one man, weren't the only domestic violence victims to spend time in jail.
We have at times found them in contempt.
At the Greene County Courthouse,
it's very rare that they don't show up, thankfully.
Judge Ken Bailey told us he occasionally holds victims in contempt of court too.
It's not easy just to say, oh yes, they're going to go to jail for 24 hours or 48 hours. I mean, those are decisions that I struggle with, and I'm confident other judges struggle with also.
Subpoenas clearly remind victims in black and white that if they fail to show up to court, they could face time behind bars. But advocates say many of these victims have good reason. They're afraid it could put them in even more danger.
It's a terrible choice. Their safety or go to jail. And that is not a position you want to put any victim of crime in.
It's especially concerning to Kathy Walsh, considering Tennessee already ranks 6th in the nation for the number of women killed every year by men. Did it surprise you to know this is happening to this extent?
Absolutely. It surprises me to know that this is happening anywhere.
Walsh, a domestic violence survivor, is the executive director of the Tennessee Coalition to End Domestic and Sexual Violence. She says the more the court system jails abusers, the less victims will want to call 911 in an emergency.
So if you have a thorough investigation from law enforcement, if they have evidence, if they have pictures, if they talk to other folks on the scene, there's no reason that you can't prosecute this case without a victim.
In some ways, a domestic violence case is harder to prove than a murder case.
Sullivan County District Attorney Barry Staubis says it's not that simple.
It's a slap, it's a hit, it's in a room, it's by themselves, and they leave.
Staubis says there are rarely witnesses, and the pictures of the victim's injuries or a victim's statement to police aren't admissible unless the victim is in court to talk about them.
You have to have in almost every case the victim to come forward and say, I'm the victim. He hit me, he did it, I reported it, and it wasn't self-defense and it wasn't accidental. He meant to do it to me.
Is there not another way to prosecute a case without putting these women in this vulnerable situation?
I don't know of any way under the current laws and under the constitutional restraints that we have that protect defendants.
Among them, a person's constitutional right to face and cross-examine their accuser in court.
If they feel that testifying is going to put them in danger, we do everything we can to prevent that from being something that they have to go through.
In addition to that situation, Emily Hutchins says if a victim's failure to appear is the result of a transportation issue or a mix-up with the date, she asks the judge to not issue an arrest warrant. Hutchins prosecutes Sullivan County's domestic violence cases in Bristol, where she says 6 victims went to jail in the last year.
I always try to take into account what they want out of these cases, what would make them feel safe and make them feel that justice is being served. But at the end of the day, these are extremely serious crimes.
Of those 6 Sullivan County cases, she says one woman, who spent 2 days in jail, actually came around after the judge held her in contempt, which led to her abuser going to jail too.
She indicated that now she knew that it was the best thing for her to come into court and hold him accountable because her not coming to court showed him that she was not going to hold him accountable.
Back in Greene County,
they're just difficult cases all the way around for everyone involved.
Judge Bailey has at times witnessed positive results too, but he says his decision to jail victims has also kept him up at night.
I've been concerned that that victim is going to endure further abuse after the case has been heard in court.
What a horrible situation.
It is a horrible situation, and it bothers me.
All right, so what's the solution? The judge thinks more victim witness coordinators in court can help the victims better understand their role in the case and how the legal system can help them. He says better counseling can also ultimately help them get out of their current situation. Josh?
It seems like, Nate, training is needs to at least be a huge component of this, especially for police, right?
Well, that's what the Tennessee Coalition to End Domestic Violence and Sexual Violence has to say about it. They say that they've trained more than 10,000 police officers across the state of Tennessee, knowing that victims of domestic violence may be reluctant. The executive director, who you heard from our story, says the practice of jailing victims goes against that training and what they're trying to accomplish.
Nate Morbido. Nate, thank you very much.
The grant Washington County uses to prosecute domestic violence cases prohibits the office from forcing victims to participate in criminal proceedings.
It's our community watchdog's latest discovery. Nate Morbido's investigation previously uncovered more than a dozen victims who were held in contempt of court after they failed to obey a subpoena.
Yeah, the agency that oversees the $216,000 3-year grant says the district attorney's office is now well aware its prosecutors can't force victims to prosecute cases, meaning under the terms of the grant, if victims are too scared, the DA's office can't demand they testify.
How do we do our jobs if any and all witnesses or any and all victims say, I just don't want to come to court?
District Attorney Tony Clark raised that question earlier this month after we asked him why, on occasion, his prosecutors push for some domestic violence victims to be held in contempt of court, including some of the most serious cases where victims allege significant acts of violence.
That's the cases that we most want people to come into court on. So we want that individual to come to court even if they don't want to, We want that individual to be in court to help us in stopping that cycle. And it could be to prevent harm to them later on or to another victim.
Moving forward, prosecutors can no longer force victims to participate in those cases under the terms of their grant agreement. We discovered that after reviewing the Stop Violence Against Women grant, which considers that act something that could compromise victim safety and recovery. We found the U.S. Department of Justice's grant information makes that same stance.
The prosecutor's office is aware that that stipulation in the grant funds that they not force the victim to testify.
Office of Criminal Justice Programs Director Bill Skolin doesn't doubt that prosecutors previously had the best intentions at heart. But he says his office's primary goal is victim safety. He and his employees have since offered guidance, not just to the DA's office, but to others involved in the process, in hopes that everyone can come to a consensus about the best way to hold offenders accountable. But more importantly, protect victims and make sure their needs are met.
We feel that the victims will be better served as of today, and these agencies will, prosecutor's office, victim service agencies will continue to meet and improve what they have going as of today.
In the meantime, he says the office's advice will allow Washington County to keep its grant money and continue to successfully prosecute the hundreds of other domestic violence cases that go before them.
It is never okay to arrest victims.
Never.
And never okay to arrest victims for not showing up for court. No, because we don't know what's going on behind closed doors.
Lynn Armstrong says she's still in shock from our original discovery that several victims spent time in jail. But the Safe Passage Domestic Violence Shelter manager thinks over time, things now will improve.
I am relieved. I'm hoping that maybe this situation brought to light something before it ballooned into a horrible, horrible mess for a lot of families. Progress takes time, and I hope that the community is looking at it from the perspective of what it would be like to be in a victim's shoes.
Nate, I understand the DA opted out of commenting about your discovery regarding that grant.
Yeah, Tony Clark says he wants to first talk directly with the Office of Criminal Justice Programs in Nashville before addressing this. The assistant director of that state office told me the DA's desire to fix this issue is, quote, huge. Jennifer Brinkman added the Washington County community has done a ton of good in recent years when it comes to combating domestic violence. And, quote, while this particular incident was not wonderful, they're doing more than a lot of other communities, and that needs to be celebrated, end quote.
Nate Morpito. Nate, thank you very much. Judges say they don't know the best solution to solve the ongoing dilemma of prosecuting domestic violence cases in Washington County, Tennessee. Our community watchdog found that in rare cases, victims are ending up in jail for disobeying subpoenas, something advocates call unacceptable. They argue that forcing victims to testify if they don't want to puts them sometimes in even more danger. Prosecutors say without a victim's testimony, it's nearly impossible to convict a defendant, which leaves the victim and the public at risk of more harm. And then there are the judges. They tell us their goals are to ensure justice for everyone involved and to keep the victim safe. The solution to balancing those goals moving forward, though, remains unclear.
State's having a hard time prosecuting these cases. I'm starting to learn. I don't have an answer, though.
When I have those kind of cases and we don't do justice or we don't get to the bottom of it, I worry about reading the newspaper the next morning that there's been a homicide.
As we reported yesterday, Washington County's domestic violence grant prohibits prosecutors from forcing victims to participate in criminal proceedings.
The rare but some say extreme practice of jailing domestic violence victims for disobeying subpoenas continues to prompt statewide conversations. Thanks for choosing News Channel 11 at 5. I'm Sarah Diamond. Josh Smith is off tonight. In an update to our community watchdog investigation, we've learned members of the Tennessee Domestic Violence State Coordinating Council raised some concerns during a meeting on Friday. The vice chair of that council is Deborah Yeomans Barton. She says the council voted concerned that the courts were holding these people in contempt without ever giving them a chance to explain their absences. The managing attorney of Legal Aid of East Tennessee says oftentimes these victims have legitimate reasons why they don't show up to testify in court, namely out of fear for their safety.
The judge should at least listen to the reasons rather than just find them in contempt of court flat out. Yeah, they are literally in contempt of court for not coming when a subpoena is issued, but give them a chance to explain the reason why.
District Attorney Tony Clark previously told us prosecutors were in talks with judges to see if there's a way to issue summons to victims instead of asking for their arrests. That would allow them to appear in court first rather than go straight to jail.
At a District Attorney General's conference today in Pigeon Forge, state officials reminded Tennessee's domestic violence prosecutors that forcing victims to testify against their abusers and then jailing those who will not cooperate will not be tolerated. Good evening, I'm Josh Smith. Sarah Diamond has the night off tonight. Community watchdog Nate Morabito found out last month's concerns about the rare but severe practice in Washington County set off a string of actions by the state,
including a visit to Johnson City in recent weeks. As we previously uncovered, the federal grant many counties, including Washington County, use to prosecute domestic violence cases prohibits the practice. Our investigation revealed here that practice resulted in the arrests of more than a dozen victims over a year's time. Emails obtained through a public records request show the state office that oversees the grant took several steps in the days after to discourage the jailing of victims.
The voices of victims.
I've been a victim who's been re-victimized.
Attorneys.
How paternalistic is it on the part of the government to think that they know what's best for these women?
And advocates.
It is deeply concerning that this could definitely endanger victims further.
All rang out loud and clear last month. Within days of hearing their stories, the Tennessee Office of Criminal Justice Programs also spoke up. Public records show the state alerted the U.S. Department of Justice of the situation in Washington County, where some victims went to jail for disobeying subpoenas. The email refers to it as a limited issue and promises it will not happen again. In addition, the office sent out a memo to all domestic violence prosecutors in the state who used the grant in question, reminding them federal funding prohibits them from forcing victims to participate in criminal proceedings and prohibits them from penalizing victims who refuse to testify, warning those activities which compromise victim safety will jeopardize their grant funding. The situation culminated Tuesday in Pigeon Forge, where state officials addressed the issue with grant-funded prosecutors in person during the District Attorney General's conference.
Every case is different. Every case has different mitigating circumstances, and those all have to be taken into account. That's one of the things that makes this issue so difficult.
Jennifer Brinkman says the state is urging prosecutors to work toward getting more victims to trust the system and work to let those victims know their wishes matter.
In the end, what needs to happen is what's best for the victim. And if the victim is not ready to testify, then those cases might not need to be pursued as vigilantly. And I think that's part of what we're looking at now is what cases do we follow up on and what cases do we dismiss because that's what the victim says is best.
Tuesday's visit followed a trip to Johnson City last month, where state officials met with prosecutors and others, including the police chief, to discuss the future of domestic violence cases.
I can see that this conversation is bringing even more voices to the conversation.
Chief Mark Soroy says from the beginning, everyone has had the best of intentions. Moving forward, he says those same people and agencies are even more focused on breaking the domestic violence cycle and improving victim safety, while still holding abusers accountable.
What the end product is going to be a better response to victims' needs, and also, hopefully, on the prosecution end, more prosecution of offenders.
Now, District Attorney Tony Clark previously told us he was looking into an alternative so that these victims could avoid going to jail instead of appearing before a judge so they can explain their situation and why they missed court or didn't want to testify. The state is also pursuing additional training to help with the investigative process so that police and prosecutors can build stronger cases so that they have those strong cases when victims just don't want to participate.
All right. Nate Morabito, thanks for the update tonight.
The U.S. Department of Justice had
has had multiple conversations with state officials about the jailing of domestic violence victims in Washington County. That's according to a spokesperson. The Federal Office on Violence Against Women has since provided technical assistance to help improve training. Our community watchdog investigation previously found more than 12 times over the last year Washington County arrested victims of domestic violence for disobeying subpoenas, even though the county's federal grant prohibits penalizing victims who refuse to testify. In a statement, the U.S. Department of Justice told us, quote, "The Tennessee Office of Criminal Justice Programs has assured us they are working with the community and that the community is making efforts to hold offenders accountable while promoting victim safety and support," end quote.